Francisco Martinez is out there. There's an unfortunately, there is someone wanted in that jurisdiction that has your name. And you see now that you've been wrongly arrested, you're going to be released today. The fear is that this...
Imagine being arrested just because your name matches someone else's? That's the nightmare Francisco Martinez is living right now. Question for you. Should police need more than just a name and birth date before throwing cuffs on someone?
This continues to happen. So I don't know, there are methods out there. And Mr. Kim, you say there's a letter that he can get.
Yes.
What we're going to do is, I cannot give you legal advice, but I'm going to have your lawyer that we've appointed to represent you tell you how you can take care of this so that it doesn't happen again. So we're going to process you out. You should be out within hopefully the next 4 to 6 hours. Ricardo will tell you how to go about getting a letter so that this doesn't happen again. Do you have any questions? Did you want to add anything, Ricardo?
What's fair to say, Judge, it's just a bad situation. This man was arrested for this, not him.
Yeah.
Here's the legal wrinkle. Officers often rely on bare-bones info like names and dates of birth. No fingerprints, no mugshots on the spot. That's why mistaken arrests like this happen more than you'd think.
Not a good situation.
Yeah, I mean, mistakes have been made, and I don't know, I guess the arresting officer, I don't understand why they wouldn't do just a little bit deeper dive.
Well, when they're on the field and it's obviously an arrest in the evening, is
theft in progress. Another officer called out on air that he was in pursuit of a black Cadillac inside the complex. The officer noticed the defendant's vehicle, the black Cadillac, drive in front of him as the officer entered the complex. The officer made a U-turn, aligned himself with the vehicle, and pulled his firearm for a felony stop. The officer gave commands for the defendant, the driver of the vehicle, to step out of the vehicle and remove co-defendants from the vehicle as well. The officer made contact with the complainant. The first complainant stated he parked his motor vehicle in the complex around 8 p.m. with the tires and windows intact, got called by the officer around 2 a.m. and noticed his front right window damaged and all 4 tires damaged. The officer made contact with a second complainant who stated she was asleep when the officer contacted her via her cell phone. She walked to her vehicle and said the tires were worth $1,000. The officer located a black Glock in the back left floorboard of the defendant's vehicle in plain view without a holster, which came back stolen once the serial number was run. The defendant's vehicle was inventoried, and the officer located 2 of the second complainant's tires in the back left passenger seat.
So he was pulled over in a Cadillac.
In the black Cadillac, correct.
The Cadillac was stolen or was not
It
stolen?
was.
Is that his Cadillac?
It was his Cadillac, Your Honor, and
in the Cadillac, there's in the back seat 2 tires.
2 tires belonging to the second complainant.
And then this gun.
And the gun, Your Honor.
The gun stolen. Where was the gun?
The gun was on the back left floorboard of his vehicle.
Was he with anyone else or was he alone?
There were co-defendants as well in the vehicle.
Where were the co-defendants?
Let me see.
And did you say that he's the driver?
Yes, the defendant's the driver.
Three co-defendants, Judge.
Yes,
Okay.
the defendant was the driver of the Cadillac.
And you have a stolen gun that's in...
Okay, pause here. This just escalated from mistaken identity to a whole new case. Now we've got a Cadillac, stolen tires, and even a stolen gun. This is starting to sound like a true crime episode, not just a courtroom docket.
The back left, you said?
Yes, the
Left back seat forward, Judge.
Okay, where are the other co-defendants?
so I'm trying to find in the dims, Your
No
Honor.
rush, take your time.
One passenger in the back seat. The office report reports that my client was asked to exit first. He exited backwards as procedure, and the other 2 co-defendants remained in the vehicle. And so I saw no objective, any kind of furtive movements, any articulation of facts that would link the gun to my client other than
Well, that's
as
what I mean,
Right.
are you,
It was in his car, which was under his control, and he's engaged in obviously other criminal activity, Judge. I think that's what.
sure, but is there a co-defendant that's sitting right there in the left rear seat?
For the left rear seat were two tires, is what it seems like.
Oh, I forgot about the tires.
Yeah.
So there's a right passenger and a
Right front passenger.
Yes.
Yes.
it would
And the
make
gun
sense.
is found under the seat of the driver.
Yes.
It would make sense that the backseat passenger wouldn't put the gun, he would put the gun where the tires are. You wouldn't expect to see a driver somehow reach all the way to a passenger side. of
Oh,
the
but I mean,
vehicle.
sometimes you've got it under your seat and then when you're moving, then the gun slides in the back. That's why I was curious as to whether there was someone sitting in the back left, but you've got tires in the back left. Okay.
Slide all the way to my client was out of the vehicle with the other co-defendants remaining in the vehicle. So there's no actual care, custody, or control articulated in this fact pattern. We're asking for.
Yeah, I get it. I was curious because I wanted to make sure. I think now that there's enough probable cause to go forward, Mr. Eaton. I am going to find there is probable cause, and I'm going to order you as a condition of your bond not to have contact with the co-defendants in this case. Do you understand?
Yes, Your Honor.
How old are you?
19.
You're 19 years old. It's not a good start, Mr. Eaton. You know, life is very, very difficult. Being a young black man in today's society is just even more difficult. And when you tack on all this stuff, does this help or does this hurt?
Hurt.
I don't want you smoking any dope. I don't want you using any alcohol. If you don't have a license, do not drive. Do you understand?
Yes, Your Honor.
The other two, I'm assuming, were arrested as well or no? Mr. Lockwood, are there co-defendants or are there no
Yes, there are.
co-defendants?
On the felony cases.
There are other co-defendants. Okay, I don't want you to have contact with these people. I don't want you to hang around with them. Do you understand?
Yes, Your Honor.
What other, did they give him any other conditions upstairs, Mr. Locklear? Like curfew or anything like that?
No, Your Honor.
No. What are you doing with yourself these days?
I go to work. That's it.
Did you graduate from high school?
Yes, sir.
Good. That's a start. You got to find something in this life to do. You ain't got no money. It's going to be a miserable life. This life is a journey. It can be a great journey where you travel, buy great things, fancy cars, fancy vacations, or it can be a rotten toilet of an existence where you're in and out of jail, no money, begging on the street. Don't fall into this life. It's not a good one. I'm not going to put a monitor on him. I'm not going to put you on any kind of curfew now, but I'm going to tell you now, Mr. Eaton, I'm going to test you within the next 2 months. If you test positive for marijuana, you test positive for alcohol or dope, I'm going to lock you up. And I'm going to tell you now, no more PR bonds. I'm going to keep my streets safe.
And there it is, probable cause. That's the legal green light for the case to move forward. Notice how the judge weighed the evidence. Even though there wasn't direct proof linking the gun to the driver, the overall situation was enough to push ahead. Do you agree with that call?
At all costs. And I don't care who you have here with you. You become a problem, I'm just going to lock you up. Do you understand?
Yes, sir.
This is where the judge gets real. He's basically giving life advice mixed with legal orders. Don't hang with bad friends, don't smoke dope, don't drink. He's trying to shock a 19-year-old into realizing how thin the ice is under his feet.
You must obtain and have a full-time job while you're on bond in this court. No alcohol, drugs, random testing, no weapons, no contact with co-defendants. Could you run his license, see if he has a license, Alex, please?
It's eligible, Your Honor.
All right, you have a lawyer. It is your responsibility to stay in touch with Mr. Locklear, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you're AWOL and you're playing games, I'll issue a warrant. You understand? You're skirting very thin ice. That ice cracks, your butt's gonna freeze. You understand? All right. Okay, Mr. Locklear, good luck. Mr. Connor, your case is 361 days old, and I'm giving you 2 weeks to have a lawyer, and when you come back, we're gonna set your case for trial. Do you understand?
Yes, sir.
If you ever take off on me again, I'm gonna triple, if not maybe quadruple your bond. No more PR bonds for you. Do you understand?
Yes, sir.
Okay, no alcohol, no drugs. I'm ready to set this case for trial. You've taken off on us repeatedly. Your case is 361 days old. We set cases for trial at 108.
Oof. That's a warning shot if I've ever heard one. Random testing, no alcohol, no drugs, no weapons. Mess up even once, and the judge says he'll lock him up without hesitation. What do you think? Tough love or too harsh?
80 days. Have a lawyer when you come back, because the next setting, I'm telling you what's going to happen. Do you understand? You see if he has a Texas driver license. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. I don't care if you have a baby that's born and you got to rush to the hospital. If you don't have a license and liability insurance, do not drive.
Yes, sir.
Do you understand?
Yes, sir. Yes, Judge.
So Felicia, normal bond conditions, please. And then Vic, 2 weeks. And next plea is trial or plea. Next setting. Come on.